Good evening, Judge Mabindla-Boqwana.
Good morning, good evening, Chief Justice. It's because I've been waiting from the morning, so I apologize
I'm
for that.
sorry.
And
No,
and good evening to the commissioners as well. Thank you.
well, I must apologize to you that we kept you waiting until now.
Not a problem. I fully understand.
How do you prefer that I address you, Mabindla-Boqwana or Boqwana? I just don't want to make any error.
Whichever comes to mind, Chief Justice, because they're both part of my surname.
All right.
Boqwana is still
Okay.
part of my surname, so it's fine.
Okay. All right. Thank you so much. For how long have you been a judge in the Eastern Cape? Is it the Eastern Cape? No, Western Cape.
It's just over 7 years now,
Yes.
Chief Justice. And if you include my acting stints in the Labour Court and in the High Court, I think it would be close to 9 years.
And it's quite a busy division, that one, isn't it?
Very, very busy, very busy.
Has it equipped you well?
Yes, very well. We actually don't have weekends and evenings because of the work, the kind of work that we do in the division.
And for how long have you acted at the Supreme Court of Appeal?
I've acted for a year now, Chief Justice, from the 1st of April last year, and I'm still acting there.
Tell us what helped you to be as ready as you believe you are for SCA appointment.
Thank you.
Yeah, as briefly as you can, but don't compromise on the key issues that you want us to.
I will try to be brief, Chief Justice, taking into account that I've been before this body in 2013 and in 2017 for the positions of the High Court, and then thereafter the Competition Appeal Court. And I outlined at the time my experience from before I became a judge. But I will just give a snapshot of the fact that from when I became a judge, I was an attorney, admitted in 1998 as an attorney. I have been a person who's also worked in a large corporation, and I've also had a stint and tried as a small business owner. And also during my time, I've been involved in a number of bodies, including the Institute of Retirement Funds, and I had an interest in retirement fund work. So I got exposed during that time in a number of areas of the law, which would be labor law, obviously, and pension law, and within itself, pension law encapsulates a number of other areas of the law, which would be commercial law, because you deal with contracts, and you also deal with administrative law, because reviews are brought, as well as constitutional law. So I got exposed to a number of those, doing due diligences and contract work for clients. And while I was still there in practice, in fact, I got a call that would change the course of my career, which actually is the reason that I'm even here. Judge Mlambo, who's sitting over there, who was a Judge President Mlambo, sorry, was the Judge President of the Labour Court at the time. And he invited me to go and act at the Labour Court. And I remember his words that he said when we sat there with a colleague of mine, Judge Kate Savage. When we started, he said to us, remember, no one was born a judge. All these people that are sitting here started where you're starting now, and they developed and became judges who are now experienced. So don't fear anything. And that was really calming, and it had a calming effect. And I remembered that throughout. And when I acted in the Labour Court, I started in 2011. Then I was asked again to act in 2012. And straight from the Labour Court, Judge President Hlophe and DJP Traverso asked me to go act in the High Court in Cape Town. And immediately the same year, I was then appointed in December of that year, after close to 4 terms, as a permanent judge of that court. Thereafter, I was asked to act in 2015 in the Competition Appeal Court. and was appointed permanently in that court in 2017 when I came before this body. And in those courts, in those 4 courts, I've written a number of judgments, and which have been interesting in a variety of matters and various aspects of the law. I got exposed in criminal law, commercial law, constitutional law, tax law, administrative law, obviously competition law. And I also got an opportunity of writing a judgment in maritime law, which was quite interesting for me, a matter that dealt with a very interesting question of what happens when a ship has been arrested in terms of the Admiralty Act, and consequent or after that, the owner of that vessel or that ship is then is then placed under business rescue. And as we know that the business rescue places moratorium on legal proceedings. And so I had to, in fact, analyze and interpret 2 types of legislation, that is the Admiralty Act as well as the Companies Act on the one side. And I had to find a way of making sure that I interpret those acts without violating the other. And then thereafter, I've written judgments in the Competition Appeal Court, and maybe I can mention some of the judgments that I've put in my pack, which I've written in the High Court. And one of those judgments is the Women Legal Center judgment, which dealt with the violation of rights of women and children that were caused or that were as a result of the non-recognition and non-regulation of Muslim marriages. In that matter, we had to actually traverse and go very deep into international agreements and international laws that South Africa had ratified, and also look into a lot of constitutional law cases and the history of how Muslim marriages were treated before. And we were of the view that clearly there was a case made that there were constitutional violation of rights of women and children. And that matter, and we felt that that matter had to be remedied by the state. And the matter went to the Supreme Court of Appeal. Supreme Court of Appeal agreed with us, indeed, on the violation, even though they gave a different remedy. Then I can also mention a case of Sonke Gender Justice, which is also a constitutional matter that dealt with whether or not the provisions of the Correctional Services Act, whether they were providing sufficient independence to the Judicial Inspectorate for Correctional Services, which we know is controlled by an inspecting judge. Currently, it's Justice Edwin Cameron who is in charge of that. So there was a challenge that was brought that in the manner in which it is currently structured, the Act does not provide enough independence for JICs to function properly. And so I found that those provisions were invalid to the extent that they did not provide adequate independence to the JICs. And the matter went to the to the Constitutional Court for confirmation. The Constitutional Court agreed with me, but just for one provision which they felt that could be read to be constitutionally compliant. So it did not to be struck.
Judge, I can see you are ready. Let me rather stop here so that some of the issues could be raised with you by fellow commissioners. Let me give the president the opportunity, but before I do, I just want to take a list of commissioners who might wish to hear more from you. Colleagues, may I have your names, please?
Sepe.
Lucas. Matoro Dlepu.
Arnold.
Mlambo.
JP, I think you're muted. CJ, sorry.
Who comes after Commissioner Matolo-Lepu? It's okay.
Have you got Barnard there as well, CJ?
You come before Commissioner Matolo-Lepu. Yes, I've got you, sir.
Thank you.
And you can add Shem.
All right. Over to you, President.
Thank you, Chief Justice. Good evening, my sister judge.
Good evening, President.
Are you well?
Very well, President. And you?
I'm fine, thank you. I don't have many questions for you. First, a comment. Everyone who has sat with you at the SCA describes you as a quick study, very hardworking, eager to learn. You've just impressed everyone. And I'd like to add to that list that you think and write well, which I think are just precious qualities in a judge.
Thank you.
Did your experience at the Competition Appeal Court help you in any way? Can you attribute these qualities to your time there? Because it appears that you have not struggled to adjust to the Supreme Court of Appeal.
Yes, my time at the Competition Appeal Court has definitely helped me because I had an opportunity of presiding because I became one of the senior judges of that court. So I had an opportunity to preside over matters. And I also acquired a lot of experience from the High Court because I got an opportunity to write interesting matters in the High Court. The JP gave me quite important matters, which I feel humbled that I was actually given an opportunity to write. That has helped me quite a lot. And as early as last week, there is a judgment that I wrote that had a competition angle in it, which came out last week. It's the question in that matter was whether the High Court had jurisdiction to hear a review application when the challenge was on the validity and the lawfulness of a complaint that has been brought against a party by the Competition Commission to the Competition Tribunal. And so the experience that I had from the Competition Appeal Court came in quite handy in that case.
You were unfortunate because your acting stint at the SCA coincided with the beginning of COVID-19 yes. lockdown. How did you find starting a new work environment on the virtual platform, and did that impede your execution of your judicial functions in any way?
Obviously, President, was actually looking forward to physically sitting on the bench and not having my bench virtually from home. And but when it comes to my work, I was not hindered at all. My work was not compromised. I was able to, when we link, to ask questions from counsel like I would and get clarity like I would if I were in the High Court. And also the post-hearing conferences that we held, we had opportunities to express our views via the link properly, and where we get petitions on a weekly basis and we're able to interact with colleagues. In fact, colleagues at the SCA welcomed me before we even started by phoning me and just inducting me on the way of doing things at the SCA and what to expect at the SCA. So, but my work, because we also have a virtual library, and when I need any extra research done, the researchers are there, and also my secretary is an attorney, so she's been able to do 1 or 2 researches for me. So I've not been compromised at all.
Good. Well, as you have mentioned yourself, you've written quite a number of interesting judgments, both in the High Court and now with the SCA.
Yes.
But I'm just going to comment on one judgment, maybe in a criminal matter which was not complex at all. But the important thing about it is that you made history and wrote it in your mother tongue is Xhosa and English.
Yes.
Why did you think it important to do that?
I'm a proponent, a president of development of indigenous languages, because I think that Afrikaans and English are where they are now in terms of being court languages. At least Afrikaans was until recently. And the legalese or the legal language or in those languages has been developed by somebody. And I think it's upon us when we can, obviously we can't do it in all matters, when we can, to write judgments in indigenous languages, especially language of the appellant and the person and language of the community from where they come. So because I think that provides access to justice in the sense that people get to understand the judgments of the court because they can read the judgment in their languages. But in doing so, I actually was inspired by you, President, because you had written a judgment, I think, in isiXhosa, which I actually admired, and I thought I want to do this because I think it's something that we need to do as judges.
And for the benefit of those who are not aware of your judgment, it's the matter of Andile Lungisa against the state that came before the SCA and then went to the Concord, I believe.
Yes.
Now, the BLA has questioned your readiness to join the SCA. And interestingly, they say you were appointed to the bench only in 2017, but then in that short space of time, you managed to act both at the Concord and the SCA. Is their write-up about you accurate? Are you a weak candidate?
I thought there was an error. I thought there must have been an error when I read that letter, because I thought maybe the author of the letter did not read my questionnaire. So I took it as that, because I felt that that comment is actually unfair because it's not supported by the work and that I've submitted to the commission, which was given to the legal bodies for them to assess. And so I thought that that comment was actually unfair, and it did not point to any shortfalls or shortcomings that could be pointed out to say, for this particular reason, we think the candidate needs to act more. But I do take the compliment that I acted in the Constitutional Court on the lighter note.
Maybe it's a prediction of things to come. Who knows? Lastly, Judge Mabindla-Boqwana, let me see. No. Let me stop here. I've asked you enough questions. Thank you, CJ.
Thank you, President.
Commissioner Tsepa?
I've been covered by the president, so I'll forego my time. Thanks.
Thank you, Commissioner Barnard.
Thank you, CJ. Judge, I'd like to, good evening, Judge. I'd like to take you to the matter of the Cape Bar versus the Minister of Justice, and just make it's a nice matter, a good matter to go to, because it dealt with a dual court. You know, it was the Equality Court on the one hand and the High Court on the other hand.
That's correct.
And in that matter, at one stage, you made a remark to say that it's really difficult when faced with a large number of counsel before you. I think there was something like 16 advocates or 17 advocates at least in court. What was particularly difficult about that matter?
I don't recall that. Can you just read out that particular paragraph?
No. It was a remark made in court as observed. It was just in passing by.
I just simply can't, honestly cannot recall making that comment. So I'm not able to answer that question because I can't recall that comment. You know, in court, you say so many things. And if it's not something that gets to be written down in the judgment, unfortunately, you're not able to go back and look at it. But if it was something that was said in passing, I can't really recall why that was made, because the judgment itself, I think maybe what we said at the end, if that's what you mean, is that we needed time to consider it because it raised important issues. We had a situation where there were arguments from the minister and the labor, sorry, and the legal practice council regarding the rationale of the scheme, the electoral scheme that was chosen. And the matter we set both as the Equality Court and the High Court. And so we had to look at the at first at PEPUDA and consider the provisions of PEPUDA as to whether or not there was unfair discrimination. And then we also had to look at the review application, whether or not there was rationality to the electoral scheme that was chosen by the minister and the LPC. Maybe that's what you are referring to, that we needed to take time to consider the matter.
Yes, thank you. Now, it's just when I thought of those remarks, I thought it's a similar situation. We have a difficult task to choose between very competent judges.
In fact, I feel like counsel now, who actually sits in court and I get to ask questions. So I feel like I'm in that position.
Sorry about that.
No problem.
If I can ask you a last, as a last question in that matter, which I suppose, although you said it didn't go specifically about the people involved, it did have at the heart of it the election of a black female to the Cape Provincial Council, or the Western Cape Provincial Council. And what was strange in that matter is there was, of the 17 advocates, there was only one female advocate that appeared before you. What was your thoughts on that?
We actually did make a remark about that. That in fact, when we saw, we thought, wow, this is refreshing. That for the first time out of all the people that have appeared before us, we get to see a female advocate. And in a matter that dealt with matters that were important, matters of transformation. And so it was disheartening. I think that's why we made a remark at the end of that judgment, that it's not enough, or transformation is not just about putting women candidates in a council. The real thing that should happen is for women and black people to be given work and to be supported, mentored, and we felt that we should not focus on the wrong fights. We should focus on the real issues, which we thought that we should make that remark and remind the parties that that is what needs to happen.
Thank you very much. Thank you, Chief Justice.
Thank you.
Thank you, Commissioner Barnett. Commissioner Mabindla-Boqwana.
Chief Justice, I hope you have me on the list. Okay, so thank you.
CJ, same to me. I think I was number 1 or number 2.
Oh, not being called yet. Okay, thank you, CJ.
And Mula CJ.
And good afternoon, Judge.
Good afternoon, Commissioner.
I'm really happy to see you here.
Thank you.
And I really want to commend you about the work that you do.
Thank you,
especially
Commissioner.
being an activist for women's rights,
Thank
especially
you.
assisting the Women's Legal Center and also Saul. So
Thank you.
all I wanted to say, I will encourage you to keep on doing it, and we'll be proud of you.
Thank you, Commissioner.
Thank you, CJ.
Thank you very much, Commissioner Mabindla-Boqwana. Honorable Nyambi.
Thank you, CJ. Evening, Judge.
Evening, Commissioner Nyambi.
Let me also join and commend you for that judgment you wrote in Xhosa and English.
Thank you, Commissioner.
But if you can expand a bit and explain what role, in your view, does language play when it comes to access to justice?
It plays a big role. It plays a big role, Commissioner. Yes, we currently have interpreters in court, and witnesses get to speak in their language, and what they say gets to be translated in English, because the language of the court is English, which is understandable, because if we have to read the record, especially when the matter goes on appeal, the judges need to understand, because not all judgments speak isiXhosa, for instance, which is my home language. It is my view that in some instances, if it is possible, where all members of the court are of the same language, if that is possible, if it is possible for the matter to be conducted in that language, that would be something that will actually contribute to access to justice in a big way. But I do understand the costs that are involved in translations, because if that matter goes up, it will have to be translated in English. So those are the impediments that we currently have, but I think we need to find ways of working around those challenges.
My last question, if you can share with us your understanding of the relationship between democracy and the rule of law.
I think they're intertwined. The rule of law is actually the founding value of the Constitution. And in terms of our Constitution, everyone is equal before the law, and all law and conduct must be consistent with the Constitution. And the courts are given the powers to hear reviews when reviews come before them. So rule of law is a founding value of our Constitution, which actually measures all conduct and all law that must be consistent with the Constitution. And democracy, we live in a democratic society that is open, which gives everyone a right to participate in our democracy in many various ways. That's how I can answer that question.
Once again, how I wish we can have more judgments in our languages. Thank you, Judge. Thank you, CJ.
Thank you,
Thank you,
Commissioner.
Honorable Nyambi. Prof.
CJ, I wanted to check if I'm there.
You were not. I will include you, Honorable Malema. Prof.
I'm covered. Thank you, CJ.
CJ Lamula, I also just raised my name. I don't know if you heard me.
I have you, Honorable Minister. Honorable Lucas.
Thank you very much, CJ. Good evening, Justice Boqwana.
Good evening, Commissioner.
I was like reading the comment that is, or the objection that was raised by the Black Lawyers Association. And after you have indicated here that you have written a judgment on maritime law, I really also want to say that I don't agree with whoever is saying this about you. And the reason why I'm saying that, I just want to explain quickly. I had a short stint as the MEC of Environment, and we used to attend international events. And there is very few of few people that is really knowledgeable about issues like maritime law and environmental law and so on. So I think you are fast becoming one of our experts in some areas.
Thank you, Commissioner.
And also the one on language has been addressed. I think it's enough. The one that I also wanted to mention was the issue on the Women Legal Centers judgment. But because in our experience, I was raising it here all the time about the issue that when we were having a countrywide program where women felt that there is no lack of compassion and accessibility in terms of particularly the law enforcement agencies as well as our courts. Now, just this year, the Parliament have actually amended the Muslim Marriages Act, and it is now waiting on consent from the President,
That's
which
good
is groundbreaking. It's really groundbreaking. But we still have an issue with regards to customary marriages and the customary law, because there is still that kind of separation. Because I think Muslim marriages, whatever it is called, it's also part of customary marriage, religious marriage. There is many things that is still not, addressed. And I would love to know, just in short, what is your view with regards thereto. And I think also the issue of legal practices, that one have been addressed by Honorable Singh, I think. So I have been covered, but I would really just in short, since you have been very passionate about the work that you've been doing for Women Legal Center, what about the issues of customary marriages?
Thank you so much, Commissioner. I think customary law, I think we've all been saying this many times, that it's our law that is relegated to the back. And even though the Constitution says it must be developed, but that has been few and far between. And it's been only in cases, a few cases, marriage cases that come to court in terms of the recognition of Customary Marriages Act, and the chieftaincy cases that come to the courts. So I think we need to do a lot more in terms of uplifting the law in that regard. And I think it's not just the judges. I would urge the legal profession, when they present cases to courts, to actually explore the angle of customary law, because the majority of us, I say us because I'm also an African woman, many of the disputes, including marital issues, are in terms of custom. And that is the kind of law that regulates people on a daily basis. But yet, it's not the law that we have given focus to. And I think we need to do that.
Thank you, Justice, and thank you, CJ.
Thank you, Honorable Lucas. Commissioner Sigogo.
Thank you, CJ. Good evening, Judge. How are you?
Good evening, Commissioner. Fine, thanks, and you?
I'm good, thank you. The reason why I wanted to speak first on this issue was to put on record the genuine mistake from the Black Lawyers Association about its comment.
I accept that.
Yeah, so I've seen where the mistake emanated from. It is from in your questionnaire when you were listing your appointments in the judiciary. You put them separately without years, and then you went to another paragraph where you put years separately, 2013 and 2017.
Yes.
So then the scriber then went with 2017. So that was a genuine mistake, and
I understand.
we do not have an issue with your suitability. That
Thank
is
you
the
very
fifth
much.
issue.
I appreciate that.
Thank you. So then the main issue, the judgment which Commissioner Barnard spoke to you about.
Yes.
You wrote so many good judgments that I've read.
Yes.
But I must commend you for the judgment in the Cape Bar versus Minister of Justice.
Thank you.
Because I believe that judgment saved the Legal Practice Council.
Thank you.
Because the Cape case was the test case, and the Legal Practice Council was going to be challenged in almost all the provinces for its election program. So then I would like to know from you, how did you see through that that case when you come to the resolution with your fellow panelists that the election mechanism of the provincial councils was not unconstitutional?
I think the starting point, as we mentioned in our judgment, I think in our introduction, was that it is not our function as the court to choose a scheme that we prefer. Our function as the court is to look at whether or not the scheme that has been chosen by the executive passes the constitutional test. And that was the issue. And so we look at whether or not the requirement of 50% male and 50% female and 50% of each of the races was rational. And we looked at the reasons that were given by the minister and the LPC, and we felt that they did pass the constitutional test. That is why we came to the conclusion that they were not unconstitutional.
Thank you very much.
Thank
you, CJ.
Thank you, Commissioner Sigogo. Honorable Minister.
Thank you very much, CJ, and good evening, Mabindla-Boqwana.
Good evening, Minister.
Yes, I just want to take from where Commissioner Skoko ended. Indeed, that judgment was very scholarly.
Thank you very much,
When,
Minister.
so we, what I want to get from you is because in that judgment and in our discussions with councils, even prior to the judgment, our biggest worry was the thin line between what is in the act and and uh, and uh, and what was declared unconstitutional by the Concord, what is called the quota system. And you will have seen that the manner and the scheme of the act, although it's not a quota system, but it allows for some kind of representation by all the parties and so forth. So my question is, how do you think we should move forward to advance transformation for the legal profession or for any scheme in the legal profession with its unique features and characteristics? As you are aware that the Legal Practice Act was an outcome of some kind of a compromise amongst the parties.
Yes.
So it does show that even most of the issues that we deal with will have to be that kind of an outcome. For example, one of the things that I asked, I think is Judge Matopo, is on the issue of the insolvency practitioners. Because it was a quota system, it was declared unconstitutional. But this one, although it's not a quota system, but we're a bit worried about that. So what is your view after having traversed that route? What could be your advice for us going forward, for the profession as a whole, but also for issues that come to us that we have to resolve in terms of transformation for the profession?
Thank you, Minister. I think that was a good starting point in my view. Now, not talking about the judgment, but just talking about the scheme itself, and not analyzing it in terms of the judgment. It was a good starting point because what it does is to say that all people, all stakeholders in the profession must come to the table and find a solution, because the Legal Practice Act enjoins the council and the provincial councils by extension to in fact transform and restructure the profession. And now, because I'm passionate about women, my topic is gonna slightly venture, but I think it will also assist in terms of transformation. I think the questions we need to ask ourselves, what are the problems? What are the barriers? Why is it that we're not getting to where we are, where we want to go to? I think we all say this, that we see young women graduating in numbers, and we're told that, I'm not sure, in some law schools there's actually a lot more women than men. And we get to admit them in court in numbers, but we never get to see them again appearing in court. And we need to find and ask ourselves a question: where are they? What is causing that? What is the problem? And one of the issues I think is the problem is the fact that the society is not yet trusting of women. The society does not see women enough as being suited for court work. And because of that, there's reluctance in giving work to women. So there must be education that starts at that level, that our society needs to change. Our society needs to know that women can be lawyers too, and litigators, not just people that are good in drafting documents. And I see this as a chain, basically. I see this as a chain because I think everyone must buy into the transformational project. I see it as a chain because I think you need client first to be educated. Client, I'm only gonna focus on big business and big banks, which are the clients that mainly come to our courts, as well as government. Those are the biggest clients. And some of the work doesn't go via the state attorneys, I understand. They can, in fact, instruct attorneys directly in some instances. So clients need to change their mindset and the perception that they have about women. And I think we as lawyers have a responsibility of influencing that change and actually getting our clients to change. And from there, from the clients, then there's attorneys. And I'm going to say big law firms because that's where most of the work goes. They need to take responsibility of mentoring people. They need to make sure that the environment and the culture is made conducive for women to thrive. And they're not just given small tasks, but they get involved in complex work. And then moving from there to counsel, to advocates, that big firms need to give a chance to women and young and Black people that are at the bar and trust them more. I always say this, because when I was in practice, this is what I used to say to companies. I'm not saying that take your work away from the people that you're currently instructing. But what I'm saying is that give me one file, because you can assess me from that file.
Judge, I get that you are passionate on the matter, but
Okay.
the CJ is gonna want us to
That's
move
fine.
on the matter. My
Yeah.
last question on the same topic that we're on, just to put you in our minds as the executive, is that on this matter in particular, as I've said, that obviously what worries us is that we do put policies sometimes. Implementation becomes difficult, or even when the policies are still being at a draft stage. As we speak now, the LPC, they are busy drafting policies that are aimed at the legal practice code or charter. But already a threat of litigation is looming by those who want to frustrate transformation. So why I say this judgment of yours was scholarly is that you're also brave as the judges of that court. Government there does not usually come back in that bench, but you took a kind of a decision that you were bold, and you could also see what is the intention of the legislation and how it is going to help in terms of the issue of transformation in the profession as a whole. So what do you think should be the groundbreaking position that will also enable us, the executive, so that when we take these kind of decisions, the courts are also able to see it through, that this is the vision and this is the direction that is in the interest of the country?
Unfortunately, I think each court will assess the case that comes before it. I'm not able to, in fact, tell you that this is what the courts should do, because I think each judge and each court will have to take a decision based on what's before them. And but in that particular case, we did look at the vision. We did look at what the minister and the LPC and the profession is trying to do, and we found that that was actually a good vision. But it's difficult for me to say that this is what the courts must do in order for them to move forward. But I don't know if I've answered your question.
Thank you. You have answered my question. I
Thank
understand your difficulty. Thank you.
Thank you.
Honorable Malema.
Thank you very much, CJ, and good evening, Judge.
Good evening.
How many
Commissioner Malema.
arms of the state do we have?
3.
What are they and what are their roles?
we have the legislature, which is its role is to make law, and we have the executive, which role is to make policy, and we have the judiciary, which is there to interpret the law and the constitution.
What is a judicial overreach?
Judicial overreach is when the courts usurp the roles of other arms of government. For instance, if the judge were to give an order that says, well, I think the executive should use this budget for building schools instead of building bridges. That's just an example. In that matter, the court is actually getting involved in the policies.
Can judges make law?
Well, judges can't make law in the sense of legislation, but in some way, because the judges write judgments, they do change the course of the law in many instances.
president of the SCS said something about Andile Lungisa. I didn't hear. What happened?
That's the case that I wrote, the judgments that I wrote and it was supported by 4 other judges.
He's my friend. Thank you.
Thank you. Thank you, Mr. Valema.
Thank you very much, Judge Mabindla-Boqwana. You're excused.
Thank you very much, Chief Justice and the Commissioner. I appreciate the opportunity.
Thank you, Judge.